Every 28th January is Data Privacy Day. Did you know that as a company employee, company data is crucial and limited to the Data Protection Act in the country? You can be sued for giving personal and private information which may be readily and easily available in this digital era, and penalties are hefty. A person who breaches provisions of the Data Protection Act is liable to a fine of not exceeding 3 million Kenya shillings or imprisonment of a term not exceeding 10 years. The Data Protection Act came into force on the 25th of November 2019 and now is the primary circuit on data protection in Kenya. Today, we'll look at how you can avoid such penalties. We are here joined by Victor Ndende, who is a data rights and privacy officer and an expert in the field, to take us through the same. And of course, you can keep the conversation going through our SMS line 21144. Thank you very much, Victor, for joining us. Well, and of course, for taking time out of your very, very busy schedule to come and join us. Now, Victor, just to kickstart, what are some of the key objectives and purposes of this Data Protection Act? Of course, that was given there on 2019. Let's just start the conversation by understanding that.
The Data Protection Act came into force in the year 2019, and it was a culmination of a very long struggle we had to get a privacy law in this country. And so it ideally came to give effect to two things in our constitution. So the first is Article 31 of our constitution, which provides for our right to privacy. And so that law actually provides for the privacy of the communications we have and also privacy of our personal information or information relating to our family. So that was the primary aim of the Data Protection Act. It came to protect these two things. So your communication and personal information relating to you or your family or your private affairs, it came to protect it from being unnecessarily revealed or required by anyone.
And on that note, as you're talking as the Act as well, what objectives in the Act capture the penalty part of the Data Protection Act?
The penalties are provided for by a penalty section within the Data Protection Act. And as you read, of course, there are penalties of 3 million shillings. There's a certain percentage of your turnover that could be charged as a fine. And there's also the imprisonment of up to 10 years.
Yes.
And so the penalties are fairly, not the very, we cannot say they're very stiff, but they were a step in the right direction in this law, in that we wanted to provide that you cannot just breach people's data and go scot-free. And so the financial costs should be enough deterrents to make sure that people respect people's right to privacy.
Victor, now let us differentiate and explain, of course, to a common mwananchi, the difference between personal data and sensitive data.
So personal data relates to you. It's data that can be identified with you as a person. And so that would be your name, your phone number, your age. That would be your personal data. Even your ID number is your personal data. But when you come to sensitive personal data is another layer of or a category of specialized data that is offered a special protection in law, because it is data that, if breached, or data that, if used wrongly, could really affect you adversely. And here we are talking about sexual orientation, the name, if someone has a child, the name of your child, or even the name of your spouse is sensitive personal information. Your marital status is sensitive personal information. Your health status is sensitive personal information. And the reason why it is sensitive personal information is because if this data leaks, someone can use it adversely against you. So for example, if your health status, which is sensitive personal information, is given to the public, if, say, for example, an employer can use it to make adverse decisions about you, if someone wants to give you a job, that can be something. Marital status has affected people in different ways. There are places where we were recently seeing some conversations online where people are saying tenants who are not married will be moved out of certain apartments. And you see, that is sensitive personal information.
Yes, yes.
And if it leaks, someone can use it against you in that manner. That there's nowhere in the transaction between me and my landlord do they really need to know if I'm married or not. So that, to that extent, that is sensitive personal information. And so if he has it, then he can now make those decisions on, I don't want single people, or I don't want married people, I don't want people who marry 3 wives, so such decision. So basically, sensitive personal information is this category of data that can actually cause a lot of adverse effects if it is breached or if it is leaked. Yeah.
And of course, let's now move from the personal self to the companies. Now there are companies that are working with third-party users. How do these companies go about protecting their data from third parties?
So the Data Protection Act applies to every person who processes data in Kenya. And there are two categories of people here that the law provides for. So there's a first category who we call the data controllers. And these are people who determine why data is processed, which data should be collected, and how this data should be processed. And then the second category we have is the data processors. These are the people who now act on the instructions of the data controller and process this data for a certain function. I could make it simple by saying, a data controller, say for example, if you enter a building, you usually sign onto a sort of a security book. The data processor, the data controller in that case is either the security company or the management company of that building. They're the ones who have said, we want the name, we want the ID number, we want signature, we want phone number. But the person who is processing that data is that security guard. Now that's the processor. And the company that he works for is also a processor because they process that information. So these two categories are required by law to register as data, as data controllers and data processors. By that fact, it means that everyone should comply with the law. So even if a company uses third parties to process data, those third parties ought to comply with the law. So that if you're interacting with a system, say for example, your mobile service provider, and they use a third party to say, for example, offer mobile credit. So like one of the major mobile service companies has a bank that runs its mobile lending facility. That is a third party. So burden is on that mobile service provider, the person you've initially given your data to ensure that the person they enter a contract with respects the law. Or is compliant with the Data Protection Act, because the risk applies to both of them. So it is always a must that everyone, so long as you're processing or handling data in this country, there's currently an obligation to register with the Office of the Data Protection Commissioner. And this registration is renewed every 2 years. And so it's provided for in law, and for those who are interested, they can check out the website of the Office of the Data Protection Commissioner.
And of course, as we have seen as one of the regulations that a person who breaches this Data Protection Act, of course, is liable to a fine of not exceeding 3 million Kenya shillings. And of course, we can see a 10-year imprisonment chance for them. Then how can we develop to implement practice on solutions that are even more positive, considering, of course, many people do not have this knowledge on data protection?
Yes, and you're very right, because our data protection law is very new in terms of laws, because 2019 is fairly recent. You know, in Kenya, we still have laws that were enacted in 1950, like our Public Order Act. But that's besides the point. The biggest challenge we have, given the new law, is an awareness challenge. People are not aware of the new law. And you see, in 2021, at Amnesty International, we did a survey across the country on, to just measure how aware are Kenyans on the Data Protection Act. And we discovered a majority, at 67%, were not aware at all of anything around data protection and the right to privacy. And so this meant that if you don't know that you have a right to protect your data, then it means you can't protect yourself. You cannot even claim and say that someone breached my data, because you don't know.
Yes.
So the first step for us to take, and luckily the Office of the Data Protection Commissioner, which is established by the Data Protection Act, has prioritized awareness in its first strategic plan to raise the levels of awareness amongst Kenyans, so that they're able to understand what this data protection is. People are able to understand what data is. You know, many Kenyans would imagine data is the mobile data we buy for our mobile phones, but data goes into those personal data that we talked about, the sensitive personal data. So if people are able to understand that someone cannot just ask me about my marital status without giving me a reason, or someone cannot ask me about my health status without giving me a reason, then we can get people to start pushing companies to comply. But you see, majority of us interact with these companies. The balance of power is, of course, in the favor of these companies. And so many people will not know how to interact with these companies in a way that they protect their data. At least in a couple of circumstances we have seen where People have been a bit concerned about their data, even the recent conversations around the Hustler Fund and why their PIN, their M-Pesa PIN is required to proceed with either registration or usage of that facility. We've seen Kenyans question Huduma number based on data. And so the awareness is slowly building, but a lot more needs to be done on that side of things.
And of course, there is a concern from many people about which point, Victor, do we say that this is enough? For example, if I go to a building, I give out my name, I give out my ID number, and of course, maybe I'm buying something from a supermarket. Even buying via M-Pesa, they'll ask maybe for my number. What point? And of course, you can see also with the Hustler Fund as well. They're asking for your M-Pesa PIN. Of course, that is bringing... A few people are questioning the fact that they are getting that information from them. Now, for a common mwananchi there, at what point, they don't have any knowledge about data protection, they don't know anything about that. At what point can say this is enough, this is the limit of giving this information?
You know, Betty, the good thing is how the law is structured. It is the duty, it is the burden of the person collecting that data to ensure that they respect our rights. It is not... The law has not placed that burden on you, who the law calls a data subject, to ensure that the person I'm giving my data complies with the law. So that burden is with, first, these data controllers and data processors, people who handle our data. They are obligated by law to ensure that they process data in accordance with the law. And when you look at the Data Protection Act, it provides for principles of processing personal data. And one of the principles there is, we call it purpose limitation, where we tell data controllers and processors are told, collect only data that you need for that purpose. So if, for example, if it's an entry access to a building, if someone was to ask your marital status on that security book, then you'd ask them, why? You know, and that's the culture we want with people, to ask, why do you need this? Why do you need my phone number? Why do you need my ID number? Why do you need my name? That type of questioning. So there's that. There's also, other than the principle of purpose limitation, is there's also a principle of collecting adequate data that you need. Just collect what you need. That obligation is placed on these controllers and processors by law. But many of them breach this law. And I think I had the report before this discussion where your colleague was talking about the mobile lenders and the amount of data that they collect. So if it's a mobile loan that you're getting, you download the application, all those are permissions, of course. Many people grant those permissions without reading. And normally we also say, even if they read those permissions, they may not understand really what the implication is. And that comes back to the awareness conversation. But the thing we were saying is, you look at those applications and the amount of data that they collect is totally unnecessary, because the purpose for a mobile loan app is to advance credit to people. And so why would that app then say, for example, request access to camera, access to GPS, access to microphone, access to gallery? Because those things are not related to credit or advancing credit or giving people loans. They're not related. And so it means then they're collecting excessive amounts of data than they need to do the operations. And what has happened is the amount of data that they've collected excessively is what they have used to actually violate people's rights, that people are threatened, because normally these apps will transfer your personal data. If, say, for example, someone defaults on those loans, they transfer that personal data that they have harvested from your phone or invasively gotten from your phone to a debt recovery company, which then uses whichever category of personal data to now harass people, to threaten people. You have seen cases where people are saying, these people threatened to call my mother-in-law, they threatened to call everyone on my contact list so that I'm able to pay this loan. It's based on the amount, on the data that they have gotten from your phone, which is more than they needed and which is illegal and which is a breach of privacy.
And of course, Victor, on that note, I'd also like to talk about, you have mentioned that the ones collecting the data are the ones who are held accountable for any form of problems that may occur. But then again, Victor, we have these security officers, just put an instance of security officers that work in these very common and maybe even small businesses. These people have no information about data protection, and of course they can be used as the primary cause of the problem. Of course they are giving back the data to their owners or whoever owns, and then they're just the primary cause of the problem, but the ones receiving the data, they're the ones who are actually bringing the problem. Then what can we say is the state of Kenya in terms of knowledge of data privacy to the security officers? Can we really say that Kenya is at a place to say that these security officers, of course, quote unquote, the others from different places, can we say that we can really hold them accountable for that data maybe mishandling?
Yes. In my view, yes, they should be held accountable because the people who have put them at the gate or the door, wherever they collect that data from, have an obligation under law to ensure that these people understand data protection. And you see, this law came into effect in 2019, and we are now like 3 years into that law. We are now actually 3 years into that law, 2 years into the establishment of the Office of the Data Protection Commissioner, who's the regulator. But up until now, people are still engaged in the same practices as if there is no law. And I would say, naturally, because of the slow enactment or operationalization of that law, it gave people a grace period to comply with this law. But people have not complied. And so when you come back to those security guards that collect this data, and one thing I'd have to point out so that people are also able to understand is that they don't collect that data because they want to, or they just wish. It's actually a requirement under another law, which is the Private Securities, which is under the Private Securities Act, the law that regulates the private security guards. That, of course, post whatever we had with our terror issues, we wanted to tighten security. So we said, let everyone present a national ID and all that. But then now, when a new law comes into place, it means that the other old laws have to conform with this new law. And so there's a chance there that we may need to look at the law that tells security guards to collect our data, but also bridge this awareness, because people need to understand that I don't need to collect some of this data that I keep collecting, because you ask yourselves, or have you ever asked yourself, where do these books go once they're filled up?
Exactly.
Yeah? People misuse, and that's where breach occurs, because that book is filled up, it's probably thrown into some store somewhere. That book is of very high value in this data market, because that's why people are complaining, say, for example, getting themselves on the register of political parties, because that book is what is just bought, and they transfer that to that database, because all we need to register you in a political party is your name and ID number, which is in a book already. And so that's how that data is transferred, and those books are sold. So the concern here is that people are not aware. Those guards are not aware. Even us who give that data to them are not aware that I shouldn't be giving all this data, that this person, I have certain rights. In fact, the law provides that you have a right to object to giving part of your personal information where you have not been provided with a valid explanation, where you don't want to consent to giving that information. And in fact, you don't need even a reason to say no. You just have to say, I don't think I can give you this information. Except where, of course, you're legally required to provide information, but ordinarily, the law provides that it is on you to consent that I want to give my data. But until then, and you see, this new law also created a very interesting thing, which is called the concept of consent. And this law does not look at consent as just saying yes. It's prior informed consent. That's what the law provides. And for you to get prior informed consent, it means that someone has to have understood what they're saying yes to. It's not that, so these data controllers and processors don't just have to say that Betty said yes. They have to say, she said yes because she understood this is what we are going to do with her information or her data.
Yes.
So it's not just a matter of yes. So the law is very protective of us, because it provides for a lot of individual rights to us to protect our data. The only thing is that we are not aware, and the people who process our data are equally not aware, and also not interested or not compelled to comply with the law. Until then, we'll still have problems.
And also, we have a lot to talk about data, but due to time, of course, we have to wind up. But before we wind up, well, I'd like you to also comment on the same. How can one authenticate a safe platform to share their crucial information? Of course, nowadays, there are people who scam you and tell you maybe you have won a certain item, you click on the link, and then it's taking you to a process that is quite similar with the known legal companies working on the same. And then the children data. How are we protecting the children data? I'd like you to address that as well as you're winding up. And thirdly, I'd also like you to address what criteria are you using to give this civil education about data protection?
Okay. Yeah, so I'll start with children, because that's also an issue of a lot of interest to us in civil society, and everyone within the data protection space, because children's data is offered a very advanced level of protection according to the law. So you cannot actually deal with children's data that easily, because you need consent of their parent or guardian, and you can only also, without the consent of the parent or the guardian, you can only process that data when you're acting in the best interest of the child. But ordinarily, what we say is that our children, one, do not understand privacy. They don't understand the concept of privacy. They don't understand the concept of their personal data. And so children are the people who are easiest to share private information without knowing so. Because if I go back to the definition of sensitive personal information, the law provides that property details are sensitive personal information. And that's why, say for example, if you're taking a photo on the streets, it is prudent that, say for example, you conceal someone's number plate.
Yes. Because
that number plate is a marker for a property. It's
not to cut you short, but Mr. Victor, could you also give the summary as well as we wind up due to time?
Yeah, and so basically what we need to do and what we're doing in the civil society space and everyone is trying to do is just build awareness amongst children, amongst adults, because without awareness we can't do much on this topic. And so also the media has a role to play in this, in advancing awareness, and the criteria, we don't have a criteria, we're working with everyone and anyone, but we are working with those communities and groups that are likely to suffer the greatest impact of data breaches. Thank you.
Thank you very much, Mr. Victor. And of course, you have given us a very detailed info. And of course, we couldn't have had it any other way. It was very, very amazing. And of course, you have had it from the expert. Keep the conversation going through our SMS line 21144 and GBS TV Africa in all our social media handles.